Thank you both. First, I want to give Professor Norton and Professor Green an opportunity to respond to each other's talks.
I'm good.
We're good? All right, I'll exercise my prerogative as moderator, too. Just very quickly on Professor Norton's, I would say that there's two other arguments in favor of actually why government speech is a good thing. I mean, one, of course, is just perhaps a way to re-articulate what you argued, is that there's a collective action problem that often can occur in the political and electoral process, where you do have well-financed, concentrated groups that are able to fund their campaigns. And to say that government can't get involved is to completely ignore the fact that government is a direct response to those problems, right? It is the prototypical collective action response, or we are acting collectively to deal with that. And then, of course, that government speech is less intrusive than direct regulation, right? So if we could, aside from the constitutional questions about often ballot issues or property taxes, if the government could regulate it directly, isn't it better in some respects to allow the government to speak about it rather than to actually engage in regulation? Professor Green, I've loved your talk because I saw it earlier, but I've been confused because it seemed like the value of it was the concern, to go back to Professor Schauer's idea of rules. Right? I mean, the problem is, in our public forum doctrine versus government speech doctrine, it's the in-between, right? It's the limited public fora cases give us such headaches, right? And the pushback is often, we want to use it and treat it as a public forum because the speech would otherwise be consistent under those circumstances with the nature of the use. But it seemed like your argument was essentially collapsing it, right? Eliminating the limited public forum doctrine.
Notice I did this without using that term at all.
Yes, well, and it's a good thing because the terms have so much weight behind them and all sorts of confusion as well. But then you kind of pull it back right at the end. Right? So I was kind of with you in the sense that the government can speak and say all of these things about whether or not it wants to promote a certain group or not, or a certain policy or not in society. But then when it opens up a platform to allow private groups to come in and speak, and it's not adopting it as its own, right? I mean, that's why I take as your point. I would be fine with the conclusion that we're just adopting it as our own speech, and we could have a broader definition of what speech is acceptable, including that there's room for debate and even equality of how to engage in that debate, because it's still the government speech. Confused as to the kind of intellectual or the theoretical distinction between that and then saying, well, it's not the government speech, but we can open it for very limited purposes.
Oh, you.
Well, obviously, this is this piece is is controversial. I mean, a lot of people aren't going to like it, and for different reasons. Fred Schauer may not like it because it doesn't have enough rules. Bye, Fred. Others of you may not like it for different reasons, but it clearly is meant to, without using the phrase, challenge the reigning orthodoxy about what are supposed to be permitted and limited public forums. And the phrasing has changed over the years, but I think at least in the Hastings case, they all use the phrase limited public forum without seeming to note that it is a term that's been, and they all seem to mean what I call opening a speech platform, and then what sort of limitations can you place on it. And the dicta has always been, except in the religion cases, that content-based distinctions are okay if they're reasonable, but not viewpoint-based distinctions. I would say the main new thing I'm trying to do in this piece is to say that viewpoint-based distinctions should be permissible in these settings, subject to all of the arguments that I make, which are arguments about, as is pretty much I do in all my scholarship, arguments about substance, arguments about norms and values. I don't really believe that there are many neutral planes we can return to. So I'm trying to push the argument on that, and the only doctrinal hook I have in my favor is that, as I say, other than the Widmar line of cases, which could be, I think, understood separately, there are no holdings on the viewpoint issue, I don't think, in this type of setting, other than dicta.
I would agree wholeheartedly. When I teach it, I always point out it's only the religion speech cases that win in the limited public forum cases. Otherwise, on pretty much any other speech is permissibly excluded.
But although these, most of these cases are still kicking around the lower courts, these cases that, Lehman would be the only one maybe that's been decided, and that's obviously quite controversial, though I offered some support for it to here today. I actually have a question for Helen as well, which is about transparency. You say Garcetti undermines public interest in transparent government speech. And you say one of the things you're working on is whether government speech is limited, whether deceptive government speech might be limited. So I just want to know, do you think there is, or what's your current position on whether there's a First Amendment right for citizens to have, like, to know what its government is up to truthfully?
I think that's actually two questions. The first one, so these are really tentative. So let's do this again next year, and then I'll tell you what I think. I don't know that there's a First Amendment right. I'm less comfortable saying there's a First Amendment right to know everything that the government is doing. I think there could be statutory rights, and that's what the Freedom of Information Act are. There's lots of statutory pressures, and we should have more statutory pressures, more mechanisms that force government to tell us what to do. But I don't know that the Constitution always compels that. The second question is the harder one, and the one that I'm wrestling with. If the government decides to speak, must it do so truthfully? Does the Constitution require it to do so truthfully? And my preliminary answer is yes, but can I point to any precedent? No, but I'm working on it.
It's a great issue.
Thank you. And I guess this one is to Professor Norton. I'm familiar with the Garcetti case, but I haven't looked at all the cases after Garcetti. But when you were talking about them, you mentioned a number of instances, and in Garcetti itself to some extent, but I think an argument could be made, not to the full extent of some of the other cases you discussed, where what the individual employees were speaking out about were things that under a lot of state statutes might fit the whistleblower protection. And so I was wondering in those cases if there was a clash in any of the cases that you know between a whistleblower protection and then this view of essentially the government employer's right to control speech and how that worked itself out.
Yeah, it's a great question. So there's a theoretical clash, but not a practical one, meaning the majority, and it was a sharply divided court, a 5-4 court, in saying there's no First Amendment protection, no constitutional protection for this whistleblower. The First Amendment does not protect whistleblowing speech if it's pursuant to the employee's official job duties. So one exception, if our prosecutor, instead of writing an internal memorandum saying, I don't think we should go forward with this search warrant because I think the police are making misrepresentations, if instead he had written a letter to the editor saying our police is corrupt, even under Garcetti, we could go forward with that claim. We'd still decide whether there's a winning, but we could go forward with it. But Garcetti makes clear that because he did what his job required him to do, which is to make judgments about police work, that was the government's job, the government's speech, and they could control it completely. They said, but then they went on to say, look, this is not so bad because statutes could protect whistleblowing. The Constitution doesn't protect this form of whistleblowing, but statutes could. Well, that's true, statutes could. But most often they don't. It's a patchwork of state statutes, and in the cases, I have dozens of cases cited in the article that's in your material, and dozens of cases that are thrown out after Garcetti, where police officers and others are truthfully reporting improprieties. There was no applicable statutory whistleblower protection. So unless and until the legislature has the political will to pass the statute, the Constitution is the only fallback, and it's now unavailable after Garcetti.
I have a question for Professor Green. I really loved your theory. I loved the article Government of the Good a while back. And I think it's interesting to, I think it's correct that it was the religion cases that erased the distinction between content and viewpoint. And I can see the idea of trying to table them and saying that that's from the Supreme Court. A lot of lower courts, of course, have kind of erased that line as well, applying the religion cases to non-religion problems. But in the court, I think that's correct. But I'm curious about your way of distinguishing them. So you say that they weren't really decided based on viewpoint and didn't really allow the, didn't really allow viewpoint discrimination, that really it was a case that they didn't have a good justification for making those distinctions. And I think that's probably true in Rosenberger and Lamb's Chapel. When it comes to good news, though, I wonder if you can really make that argument. Because, of course, it was a mostly Christian school. It's a Christian revival meeting, practically a religious class that's going on immediately after school in the lower grades. It seems to me that there'd be a lot of good justifications for not allowing that, especially in a case when you wouldn't expect there to be an alternative viewpoint coming up. So do you think it's part of your argument? Do you think it's necessary to your argument to distinguish those cases? And if so, what do you think of my problems with good news?
So, in that set of cases, one type of problem which could come up, which I have not addressed today at all, is involvement of the school, which could raise establishment clause problems. So put that aside. I'm not addressing those issues at all. Another issue could involve unequal access. I'm not addressing those issues at all. I mean, unequal access if you only, if you don't let the minority group. Right. But I actually think that I have been persuaded over time that, assuming we agree with the Establishment Clause holding, which, again, I'm not talking about today, the core, in all these cases, basically, there's an Establishment Clause aspect to it, which is, and the Court has said consistently, as long as these school rooms or funds are open equally, there's no endorsement, there's no favoritism, it's just, right? And so if that's true in these cases, then I think that there is, in fact, no good reason for not letting the religious group meet, assuming there's no school involvement. And that's what I mean by if the school were to exclude them, it might be viewpoint based. But the reason it's problematic isn't simply that it's viewpoint based; it's that it's viewpoint based without a good reason. Whereas I suggest there are other type of there's no good reason once we kick out the Establishment Clause concern, I think, to not let these groups meet. So that's sort of my answer to that. Over here.
I'm going to address this to Professor Green. I was telling several of my faculty colleagues that about every 2 years or so, in my basic tax course, I do the Bob Jones University case. And I've always found the Bob Jones University case very troubling. I've never been able to understand why the lawyers in Bob Jones didn't raise a First Amendment issue instead of letting the entire argument turn on the meaning of the word charitable that was tortured out of all proportions. Where exactly would you support the result in Bob Jones today? Or would you say that if a First Amendment issue had been raised, that they could always speak on their own nickel? Although I might add that if you disallow an exemption for Bob Jones, that in effect means that donors cannot make charitable contributions, deductible charitable contributions, and that has severely impacted that school happily.
And so just remind not a tax, so this was an exemptions case?
Yeah.
Just remind me the tax
the court
fact
said that
about it.
The Internal Revenue Service could deny an exemption to Bob Jones because it espoused what was basically a view contrary to
that means that
policy.
That means I can't make the deduction to it as a charitable organization. And does it affect their coffers in other ways as well, as a tax matter, other than the individual?
No, but I think that loss of the ability to attract charitable donors.
Yeah, no, I just wanted to know the fact. Yeah, I mean, I haven't read it in a while, but I think it's correctly decided. I mean, I think that, I don't know if I would I haven't read it in a while, so I don't know if I'd write the opinion the same way. But I think the government can refuse to provide funding for groups that discriminate on bases that it considers invidious. That's how I would answer it. And I would view that as a kind of funding. I would view the tax, any type, this is where I don't know tax law went up, but I view any of these sort of tax consequences as a type of funding. So.
That case refused to say that this was a subsidy.
Yeah, you see, that's where I would have, that seems wrong to me, so, okay.
There was a First Amendment claim in Bob Jones. It was under the Free Exercise Clause, which is also in the First Amendment, and the court blew it away in a couple of sentences on compelling interest grounds. The question I put in my hand to ask is for Professor Norton. I've been naively telling my students for years that the Establishment Clause is a very special rule that on secular political matters, of course government can try to lead public opinion. That's what governments do. And so it's a very special protection to say government can't take positions on religious questions. I had no idea about these cases you described, saying government can't try to get its bonds passed and so forth. And I'm wondering, in recent years, not going back to Justice Brennan on the New Jersey Supreme Court, but in recent years, is there a political valence to those cases coming from the right, and are those claims being accepted by conservative judges, or is this coming on both sides? And is it confined to referenda, or do these judges believe the president can't try to rally support for the war effort or the bailout or the TARP fund? And do these same judges think it's just hunky-dory if the government wants to sponsor religion?
So those are a terrific set of questions. I too was really surprised by these cases. I stumbled across them in writing another article, which is how a lot of articles come about. I stumbled across this Brennan opinion from 1953, which then gets cited for decades to come, and I was stunned by it. Brennan, when he's on the New Jersey Supreme Court, says a school board can't tell voters to support schools. I found it astonishing. I want to be clear that there are some trends, although they're not perfectly chronologically divided, that the more recent trend is to be deeply suspicious of these claims. The more recent trend is for courts to be pretty comfortable with government's political advocacy. It is not, it's not an unmitigated trend. We do see some outliers even today. But over time, we do see the courts starting out with Brennan in the 50s, deeply suspicious of government's political advocacy period, whereas today, for the most part, more courts are pretty comfortable with government's political advocacy. I have a couple of theories about that, but I really invite other theories as well, because I've puzzled over this. I think in part it's because in the last 20 years we've seen this term government speech emerge for the first time as a matter of constitutional doctrine. Government has been speaking from the beginning, but we didn't give it this fancy name with significant constitutional implications until arguably 1991 or maybe thereafter. And maybe the fact of naming it has given more comfort with something that's been going on all along. The political valence, I mean, is. I think these. I don't know how they feel about religion. I haven't sort of checked that at all. But these are judges on the left and judges on the right. And Brennan is on the left, and he changed his mind over time. We still see these claims today, and I'm actually sort of suspecting that we're going to see more of them with the growth of the Tea Party. Deeply suspicious of governmental roles in many respects. So why not deeply suspicious of government's participation in contested political debates? Which is why I think it continues to be a live and important issue.
This question is for Professor Norton. I noticed that a lot of the examples you were doing about with contested government's speech in elections dealt with a lot on the local level. I'm wondering how your theory applies when you're dealing with it more on the national level, specifically when you might be going against national speech versus, say, state speech. In specifics, I'm thinking of drug policy. It's the federal government's position that marijuana is an illegal drug, but you're now seeing a lot of states engage in ballot initiatives to make it legal. Arizona recently passed one allowing it for medical purposes, and in California it narrowly failed for allowing it for recreational purposes. Do you think it is permissible for the federal government to get involved to weigh in on state ballot initiatives on these issues?
Oh, you mean so like if President Obama or Attorney General Holder were to say to the voters of Arizona, y'all, you should vote against this is a bad idea?
That's exactly what happened in California, where both President Obama and Eric Holder said this should not pass because this will we will enforce our federal laws, et cetera, et cetera, et cetera.
Right. So that's a great question. If we're just talking about the speech, I actually don't have a problem with it. And you're reminding me of another example that this is a live issue on the federal front, meaning for years, certain members of Congress have been unhappy with executive branch advocacy on legislative matters. And this started in the 1950s when Eisenhower was trying to pass a health care proposal. And he and his executives, the then Secretary of HHS, the HHS precursor, were going around the country trying to drum up support for this administration bill. Members of Congress thought it was inappropriate for the executive branch to go to the public on a legislative matter. Passed in 1951 an appropriations rider that prohibits executive branch officials from engaging in publicity or propaganda. Publicity or propaganda is and never has been defined, so it's largely unenforced, but it has remained on the books in the 60 years since then as an expression of congressional unhappiness with the executive branch going to the public on a legislative matter. Now, of course, the executive branch does this all the time, which is why it's largely unenforced, but it shows sort of the clash of values, that some folks think that government shouldn't be talking to folks about certain issues that other government bodies are going to be decided. So you're raising also a federalism issue, right? Should an executive branch official go to state folks and tell them how to vote? And I don't have any problem with that for all the reasons that I identified in my talk. I think that's another voice to add to the marketplace of ideas. Sometimes that executive branch official will have special expertise that's relevant on the law enforcement front. Sometimes that executive branch official will be a really valuable heuristic for an uninformed voter. I love Eric Holder. I hate Eric Holder, but depending on how I feel about Eric Holder, that's going to help me figure out how to vote on this initiative. Certainly we know more about Eric Holder and Barack Obama than we do about a lot of private organizations that will be mobilizing around that issue that are not identified by specific individuals. Again, this is sort of one of the situations where I think the more government speech, the better. And you can imagine back in California in the 1990s when California was considering an initiative that would end state affirmative action programs. Bill Clinton advocated against it, saying, this is why I think affirmative action is valuable. You might love Bill Clinton, you might hate Bill Clinton. That was valuable information for you to have as a voter, how Bill Clinton felt about that issue.
Just a quick follow-up question. So I want to push it a little bit more. So assuming that there were some discretionary funds available in some agency, would it be constitutional in your view for the U.S. government to spend money running a big ad buy in California? It is the view of the U.S. HHS that you should not vote for recreational marijuana. Would that be constitutional?
Yes, I think that would be constitutional. Again, I don't think the government has a First Amendment right to do that,
right.
So you could prohibit it as a matter of statute.
There'd be no claim against it.
Yeah.
I have a quick question for each. So, Abner, what if the reason offered in the Good News Club was that they were trying to avoid controversy, and so they wanted to preclude all religious groups, pro and con, from meeting? That's your question. And for Helen, is much of the persuasiveness of your argument dependent on the assumption that government speech is more likely to counteract powerful private speech than align with it? And if so, I'm sure you don't have any empirical evidence to support that claim. What would be the reasons why government speech is more likely to be counteracting private speech rather than aligning powerful private speech and exacerbating that problem?
You go.
Yeah. So, excuse me. Thank you for that question. It's one of my several arguments. I have several theories for why government speech here is especially valuable. One, but certainly not the only one, is that it sometimes is a counter to powerful private interests. I don't pretend that that is always the case or even most often the case. You're right, I have no empirical data. All I can tell you is the times when government gets sued for speaking is when it counters powerful private interests, which is why I want to preserve the opportunity for them to do so.
That was great. So, I basically need to work through this a little bit, but for me, so what are the factors that matter? The context, the type of platform, which might otherwise be called forum, but I'm trying to not use that word. Because I think the word platform is evidential of something. And also, there's an issue in all these cases about the scope of inclusion and the scope of exclusion that I think can be probative of what's going on. So, I don't love the Lehman holding. That's the one where it's from here, right? No, it's from Ohio, right? Shaker Heights.
We have a spoils on the case.
What's that?
We have a spoils on
There you go. I've never been to Shaker Heights. Maybe we could do like a little road trip. So in Lehman, they basically say we want commercial ads only, right? And we're going to exclude other stuff. I may not have the facts exactly right. And to me, so that's fine because it seems that it's pretty clear that they just want to raise revenue from, and that anything else, I don't know if it wasn't anything else, but in my ideal world, let's say it's anything else that might be at all beyond the sort of commercial realm would be excluded, so I can understand what they're really up to. So in the school setting, if the school opens its clubs for everything but religious groups of any sort, right? Yes, school space. Right. Meeting space. Right. If the school opens its meeting space for every type of group to do whatever they want to do, except religious groups or any group on the issue of religion, we're going to assume. See, the problem is, it strikes me that the notion that we're just wanting to avoid controversy doesn't quite strike me correctly, because then you'd want to exclude all political discussion groups and policy. So then just leave. Now, if the school says we just want to have the sports teams and the chess clubs and the mathletes and not have any political groups or religious groups, then I might say it's stupid, but it's probably I would say it's probably constitutional, I think. But just religion strikes me as
Controversial.
Yeah, I get.
Including religion.
I think I would say that's stupid, but fine. I think is what I want to say. I mean, that's a weak interest, right? Avoiding disparagement by race is a strong interest. Avoiding vulgar speech is a medium interest. Avoiding controversy is a weak interest that I'm working through a little bit, but I think it's probably okay if it's a broad enough exclusion.
I had a question for Professor Green, specifically about your hate speech exclusion. The definition of hate is fluid, and it changes with time. And if we say that, we've seen some examples of that here today, even, or if you soften it to persecution. If you have this hate speech exclusion, are you going to interfere with the marketplace of ideas over what is hate?
Yeah, so this is the key objection. This gentleman is posing a version of the key objection. I think of as the key objection to my argument. Let me just give a little history on that. Sadly, he's left again. Fred Schauer was my professor at Michigan, taught me in a course called the Critical Legal Studies Movement, which was interesting if you know Fred and know the Critical Legal Studies Movement. It was a great class, and I learned a lot from him. And he was helpful in initially going on the market and helping me prepare. He was just a great, fabulous mentor. And when I started teaching my free speech course, I started relying on and still rely on his great book from early in his career called Free Speech, A Philosophical Inquiry. This is getting back to your question. And what Fred does in that book, and I recommend it to all of you, is, in his beautifully cogent, clear way, takes us through all the justifications for why we have a special free speech principle. Why do we treat speech specially even though it can harm, right? That's why it's an interesting issue. And he goes through autonomy, democracy, truth, and sort of says there's something to all of these, but it's not complete. Ultimately, the key reason if I'm remembering correctly, that we have to treat speech specially is the concern that we can't draw lines properly. I think he calls it negative theory. We just don't trust the government in these sort of ideological areas to consistently draw lines properly. We have to set up a rule, and the rule is our free speech rule against content-based decision-making. The core of my piece here really is to try to say that makes sense, and we need it in regulation of private speech, and although it is underdeveloped, in streets and parks. I mean, this streets and parks is this intermediate area. But I'm trying to push the idea that because there is also great harm from hate speech, and even though it will have to be defined by each school who's administering their after-school program, or each city that's administering its buses or subways or its adopt-a-highway signs, and local officials are going to have to make these judgments, that I'm willing to say we should risk the case-by-case failure of those judgments, the ad hocery of those judgments, and weigh more heavily the protecting of the vulnerable persons in this setting of speech platforms, whereas we would not allow that ad hocery in the broader setting. I mean, I'm trying to thread a needle a little bit here, and I recognize that this is the core problem, contention against my position. But I just think sometimes we can say, more concerned about ad hocery here, more concerned about protecting people from hate speech here, and sort of let it filter out that way.
Here, and then one back there.
It was said that, let's see, it was said that the government has the right to limit to promote certain speech, and to limit certain other speech. But wouldn't it be better if the government promoted open forums so that people of all political hues and stripes may present their platform? If the government wants this image of being non-totalitarian and valuing citizen participation.
That's a great question, and I actually am all in favor of that. That is nothing in I didn't talk about it here, but I don't want anything in my paper to suggest that I'm not a big fan of government providing space and funds for everyone to speak. That is, I think that parks with band shells and auditorium spaces and Hyde Park corners sponsored by the government without limitation on content are fabulous things. And I think that government providing, I in fact think, there's a line of free speech scholarship, although not Supreme Court doctrine, that suggests the government sort of has an obligation to more positively provide seed money and space for 1,000 flowers to bloom, even if we hate them. So I'm actually all in favor of that. I'm thinking of Owen Fiss and Cass Sunstein a little bit in their work. So I would favor a robust streets parks forum provided by the government, and then other specific platforms. We'd have to figure out exactly what they were, where the government can say, here we want to tailor it some more in a certain way. And exactly how I draw that line, I'm a little less clear about, but I'm in favor of robust in both areas.
Excuse me. My whole premise is based on the notion that government is not shutting down other vehicles for campaign speech. That would be completely repugnant to the First Amendment. My argument is that to the extent that people are talking about campaign issues, they're talking about ballot measures, they're talking about legislative proposals, that there should be no constitutional exclusion of the government from that discussion.
That leads into my next question. And when the young lady stated about whether or not you agree that the president or the attorney general should speak out on issues such as the drug policy, wouldn't that be the same as when you have a presidential election and they speak about abortion or same-sex marriages, which was really the platform outside of the war in Iraq for the 2004 election? Do you agree or disagree?
I think government can and should talk about the issues. I think government should talk about controversies. I think the more discussion of issues, the more we know about what our government thinks about issues, the better, period.
I just want to say the one thing that, since a lot of you are students here, I know, or continuing students, that's a really interesting issue here that people in this field of government speech have written a lot about, but there's still some unsettlement, is this transparency concern. That is, there isn't yet a holding on the part of the Supreme Court that the government has to be transparent when it speaks. And in fact, there's some suggestion in the Johans case, the beef it's what's for dinner case, that the court doesn't really think it's a requirement. I mean, if you should read the exchange between Scalia and Souter on this, and there are a lot of scholars pushing back on them. I mean, part of Helen's argument is that it has to be transparent. If I recall correctly, in the Bush administration, part of the reason they got flack for some of their propaganda was that they were hiding it, right? They were pushing it but hiding it, making it look like it was a private speaker. So this issue of whether the government has to own up to its own speech is a big one, and I think the court is not yet through grappling with it. I think there's going to be more on that. I hope there is more on that.
Well, and that was my concern about in your paper, in your talk, that it kind of creates a gray area in which these limited platforms or limited speech platforms could allow the government to kind of both have its cake and
there I'd want to respond in the way that Mary Jean, I mean, I would like there to be more disclaimers or signs or transparency. I mean, I want it to be clear when it's the government, when the government's just saying, we're opening this for groups, but not the hate groups, and just to be clear about its role, I think is significant in a lot of these areas.
Great. Thank you all, and it's been a wonderful day.
Thank you, Professor Norton.
Thank you, Professor Green.